There is a document that exists in the history of American corporate law that should not be possible. A spreadsheet, created by engineers and accountants working together inside one of the largest corporations in the world. The spreadsheet has columns. One column lists the projected number of people who will die because of a known defect in their product. Another column lists the projected cost of the lawsuits that will result from those deaths. A third column lists the cost of fixing the defect before anyone dies. The spreadsheet has a bottom line, and the bottom line says that letting people die is cheaper than fixing the problem. And then somebody signed off on it. What you are about to hear is not a conspiracy theory. It is not speculation. It is documented in court records, in internal memoranda that were subpoenaed during litigation, in the testimony of engineers who were in the rooms where these decisions were made. The document exists. The calculation was made. The decision was taken. And the people who made it understood exactly what they were deciding. They decided that your life had a number, and that number was smaller than the cost of fixing what would kill you. By the end of this video, you are going to understand not just what happened in the specific cases where these calculations were made and discovered, but why the system that allowed them to happen is still operating today. Why the calculation is still being made by different companies with different products, using more sophisticated spreadsheets, reaching the same conclusion. This is the story of the cost-benefit analysis of human life and the corporations that decided you were not worth saving. To understand how a corporation arrives at the decision that deaths are cheaper than a recall, you need to understand a concept that sounds reasonable in the abstract and becomes monstrous in its application. The concept is called a cost-benefit analysis, and it is used by every major corporation and every government regulatory agency in the world. The basic logic is genuinely defensible. Resources are finite. Decisions about how to allocate those resources require some framework for comparing costs and benefits. A pharmaceutical company deciding whether to conduct additional safety testing must weigh the cost of that testing against the benefit of identifying potential harms. A car manufacturer deciding whether to add a safety feature must weigh the cost of that feature against the benefit of the accidents it would prevent. The framework requires, at some point, placing a monetary value on human life. This is not unique to corporations. The U.S. government does it officially. The Department of Transportation uses a figure called the value of a statistical life, currently around $11 million, to evaluate whether safety regulations are cost-effective. The Environmental Protection Agency uses similar figures. The Food and Drug Administration uses similar figures. Placing a monetary value on human life for purposes of policy analysis is standard practice across both government and industry. The difference between legitimate cost-benefit analysis and the kind that appears in court documents as evidence of corporate homicide is subtle but absolute. Legitimate cost-benefit analysis asks whether a safety investment is justified given its costs and its benefits. The monstrous version asks whether the lawsuits from the deaths will cost more or less than the fix. One is asking whether we can afford to save lives. The other is asking whether we can afford to let people die. The Ford Pinto case is the most famous example in American legal history. In the late 1960s, Ford Motor Company was under competitive pressure from smaller foreign cars entering the American market. Lee Iacocca, then Ford's president, pushed for the development of a subcompact car that would weigh under 2,000 pounds and cost under $2,000. The Pinto was developed under extraordinary time pressure, with the design and tooling processes running simultaneously rather than sequentially. During development, crash tests revealed a significant problem with the Pinto's fuel system design. The fuel tank was positioned behind the rear axle, between the axle and the rear bumper. In rear-end collisions at relatively low speeds, the tank could be punctured by the differential bolts, causing fuel to leak and potentially ignite. The fix was well understood. A rubber bladder inside the fuel tank would prevent puncture and leakage. The cost of the fix was estimated at $11 per vehicle. Ford's engineers documented the problem. Ford's management conducted a cost-benefit analysis. The analysis compared the cost of implementing the fix across the projected production run of the Pinto against the projected cost of litigation from the deaths and injuries that would result from not implementing the fix. The analysis used figures provided by the National Highway Traffic Safety Administration itself, the government agency responsible for automobile safety. It valued each death at $201,000. Each serious injury at $67,000, and each burned vehicle at $700. It projected 180 deaths and 180 serious burn injuries over the production life of the vehicle. The total projected litigation cost from those deaths and injuries was calculated at approximately $49 million. The total cost of implementing the bladder fix across the projected production run was calculated at approximately $137 million. The fix cost more than the litigation. The decision was made not to fix the Pinto. This calculation became public during litigation following a 1972 accident in which a Pinto was rear-ended and burst into flames, killing the driver and seriously burning a passenger. Subsequent litigation produced the internal documents, including what became known as the Pinto Memo. When those documents were published and became widely understood, the public reaction was one of the most significant moments in the history of American consumer protection. The idea that a corporation had explicitly calculated that your death was cheaper than fixing the product that killed you crossed a moral threshold that could not be uncrossed. Ford was eventually ordered to pay punitive damages in a California case, though the award was later reduced on appeal. The National Highway Traffic Safety Administration eventually ordered a recall of the Pinto in 1978. By then, an estimated 500 people had died in Pinto fire accidents. Ford estimated the recall would cost $11 per vehicle. The Pinto was the case that made the practice visible. It was not the case that ended the practice. General Motors conducted similar analyses in connection with defects in its vehicles. Documents produced in litigation over GM side saddle fuel tanks on pickup trucks revealed internal analyses that compared litigation costs to recall costs and concluded that the existing design was financially preferable despite the fire risk created. GM paid enormous settlements in individual cases while maintaining that no recall was warranted, a position that is only explicable if the litigation cost calculations were driving the decision. The tobacco industry conducted perhaps the most extensive and well-documented version of this calculation over several decades. Internal documents produced during the landmark tobacco litigation of the 1990s revealed that tobacco company researchers had understood the addictive and lethal properties of cigarettes decades before that understanding became public. The internal documents showed not just awareness of the harm, but deliberate strategies to maintain that awareness as proprietary information while publicly denying it. The calculation in the tobacco case was not precisely the same as the Pinto calculation. It was not purely about comparing litigation costs to fixed costs because there was no fix for cigarettes that would maintain their commercial viability. The tobacco calculation was about something arguably more disturbing: the deliberate decision to maintain and exploit an addiction that killed customers, because the profits from that addiction were calculated to exceed the litigation costs from the deaths. Documents produced in litigation showed tobacco executives discussing the health risks of their products in terms of their financial implications. They funded research designed to create doubt about the scientific consensus on smoking and health, a strategy that has been extensively documented and that cost billions in settlements when it finally came to light. The calculation that underlies the entire strategy is clear. The cost of maintaining the deception, including eventual litigation costs, was calculated to be less than the cost of the alternative, which was admitting the truth and losing the market. Purdue Pharma and the opioid crisis represents the most recent and arguably the most devastating example of this calculation at work. Documents produced in the Purdue Pharma bankruptcy litigation revealed the internal thinking of the Sackler family and company management with extraordinary clarity. The company knew that OxyContin was highly addictive. It knew that its marketing strategies were driving addiction and death. It had access to data showing the correlation between its sales efforts and the overdose rates in specific communities. McKinsey & Company, The management consulting firm hired by Purdue to advise on its marketing strategy produced internal documents that are now part of the legal record. One document discussed ways to, quote, turbocharge sales in response to the growing awareness of the opioid crisis. Another document, which became particularly notorious, calculated the financial benefit of various strategies by comparing increased sales revenue against litigation exposure. The document included a discussion of what it called OD deaths, meaning overdose deaths, and calculated the financial implications of those deaths in terms of litigation costs. The McKinsey document did not recommend letting people die to avoid a recall cost in the way the Pinto memo did. But it demonstrated the same fundamental analytical framework. Human deaths were a line item in a financial calculation. The question being asked was not how do we stop people dying? The question being asked was how do we manage the financial exposure from the deaths while maintaining the revenue that causes them? McKinsey eventually paid approximately $600 million in settlements with state attorneys general over its role in the opioid crisis. The firm admitted no wrongdoing. No McKinsey consultant was criminally charged. The partners who worked on the Purdue account continued their careers. The question that these cases collectively raise is why the cost-benefit analysis of human death keeps being made, keeps being discovered, and keeps resulting in fines rather than prison sentences. The answer is a combination of legal structure, regulatory design, and the fundamental economics of corporate liability. On the legal side, proving that a corporation made the calculation and acted on it is genuinely difficult. The documents that reveal the calculation are usually protected by attorney-client privilege, meaning they can only be obtained through litigation discovery, which requires someone to be injured first. By the time the documents emerge, the corporation has years of litigation experience, teams of expert witnesses, and virtually unlimited resources to contest every element of the case. On the regulatory side, the agencies responsible for product safety have limited authority and limited resources. The National Highway Traffic Safety Administration can order recalls, but it cannot initiate criminal prosecutions. The Food and Drug Administration can remove products from the market, but its enforcement actions are predominantly civil rather than criminal. The regulatory framework is designed to produce compliance, not punishment. On the economic side, the fines and settlements that corporations pay when the calculation is discovered are treated as a cost of doing business. They are paid from corporate funds, not from the personal assets of the executives who made the decision. They are often tax deductible. They do not result in criminal records. They do not result in imprisonment. For the executives who signed off on the calculation, the personal downside risk of making it is essentially zero. What would change the calculation is criminal prosecution of individuals. If the engineer who signs off on a cost-benefit analysis that explicitly values corporate litigation savings over human lives faces personal criminal liability, the calculation changes. If the executive who approves that analysis faces the possibility of imprisonment rather than retirement, the analysis changes. The Pinto case came close. Ford was criminally indicted in Indiana in 1980. One of the first times in American history that a corporation had been criminally charged with reckless homicide for a product defect. The case ultimately resulted in acquittal, partly on technical legal grounds, and partly because of the difficulty of proving corporate intent to a jury beyond reasonable doubt. No individual Ford executive was ever criminally charged. In the decades since, despite numerous cases where internal documents have revealed calculations that placed financial considerations explicitly above human life, criminal prosecutions of individuals responsible for those calculations have remained extraordinarily rare. The framework for such prosecutions exists. The evidence, when documents are produced in litigation, is often compelling. The will to pursue them has been absent. The calculation is still being made. It is being made with better software, by more sophisticated analysts, in more carefully worded documents designed to survive litigation discovery. The explicit language of the Pinto memo, the specific comparison of litigation costs to recall costs, has been replaced by more defensible analytical frameworks that reach the same conclusions while creating less evidentiary exposure. The product changes. The spreadsheet evolves. The conclusion remains the same. Your life has a number, and that number is smaller than the cost of what would save it. If you believe the public deserves to know where the money actually goes, subscribe. Every week we cover the frauds, the scandals, and the financial crimes the system would rather you forget.